All right, good morning. I'm going to give everybody a couple of minutes to get their video up and running. I still have people coming in. So it appears, Ms. Anna, yours is probably going to be the longest hearing today. So I'm just going to let y'all can just watch it. Everything else should be pretty quick, but we'll
Okay.
come back to that case once I finish with the shorter cases.
Judge, is it okay if I just stop my video and go grab a cup of coffee?
You may.
Thank you, Judge.
So no one appeared on the Ford matter. That matter is going to be passed. So Ms. Sparks, whenever you
Yes,
get your
Your Honor.
video up and running, I'm going to take you.
Okay.
How are you this morning?
I'm good. It's spring break, but I'm here. How are you?
So on yours, we had the possession, the only issue that the court has with it is the possession schedule. And we're not
Yes,
in
sir.
any way trying to get in the way of an agreement.
Mhm.
It's just we want to make sure that the order is enforceable. And I had a little bit of concern with the start time for the
We're gonna be the
periods
last
of
ones.
possession because red
So where am I?
on. Can you hear me, Ms. Sparks?
Yes, I'm sorry. It was a little overlap, but I can.
So I'm not sure if I cut out on there because I was getting someone else talking. But what the issue that the court has with your possession schedule, the way it's written is the start time reads that it's either 6 p.m. or when school lets out or when an extracurricular activity lets out. And the extracurricular activity is the one that is I think potentially, or not potentially, I think it's going to make the possession order unenforceable if there was a contempt, motion for enforcement filed. And so that's the language that we really need to figure out a way to get that where we accommodate the parties' agreement, but we also have it written in a way that is not going to create any enforceability issues if you do something wrong. So my thought is we either do later of 6 p.m. or when school lets out, which is fine language,
Okay.
and then deal with the extracurricular activity stuff maybe in a separate paragraph that just says, and I forgot, I don't have the order in front of me, but mom has the right to take the child to extracurricular activities or something along those lines where you effectuate their agreement, but that we clean up that language on the start time for the possession schedule. And once that's done, you can do you already have a proof of affidavit on file.
Yes, Your
If you
Honor.
can just tweak that one part of the possession schedule, then we'll sign the order and grant the divorce at that time.
Okay, so we want to get this to you today. Just let me be clear. So you're saying the or extracurricular activity is the issue with the court. So instead of saying or extracurricular activity, just leave the regular possession language and put a separate paragraph regarding and her extracurricular activities, and then mom has the right to take her to them. Okay, Judge, we can make those
Correct.
corrections.
And then
I'll get those to you this morning.
yeah, and then what'll happen is if you want to, we can go ahead and do a prove up right now since your client's here, and I can render the divorce for you, and then just set you an entry date like for next Friday. And then as long as you just get that order in to me before next Friday, I will sign it. There was another provision, and I don't think it's a problem, but it basically the alternating weekend says that it's to start not earlier than the Friday within 10 days of the date the divorce decree is signed, I think is, let me look at that actually.
Well, Judge, I think
I'm thinking
the
Go
biggest
ahead.
issue is the child is now 18, and she's 18 years old now, and she's in her senior year. She's driving. The parties have been together. They live in the same neighborhood a block away.
then I'm not worried about the possession schedule.
Okay,
This is an
right.
18-year-old child?
Yes, yes.
Okay. Let's go ahead and do the prove up and I'll take care of you now.
Okay.
Let's see. Miss Wood, are you present? Miss Wood, if you would please raise your right hand for me. You solemnly swear or affirm the testimony that you're going to give in this cause will be the truth, the whole truth, and nothing but the truth.
I do.
All right, Ms. Sparks, you may proceed.
All right, Ms. Wood, will you please state your name for the record?
Sarah Vernier Wood.
And are you presently married to Chris Wood?
Yes.
And have you and Chris lived in Texas for the past 6 months and been a resident of the county for over 90 days?
Yes.
Were you married to Chris Wood on August 20th, 2002?
Yes.
And did you and Chris stop living together October 15th, 2018?
Correct.
And would you agree with me your marriage to Chris has become insupportable because of discord and conflict?
Yes.
And there's no likelihood that you and Chris are getting back together?
Correct.
And was there a child born during this marriage?
There was.
And is that child Miss Maya Wood?
Yes.
And is she now 18 years old?
She is.
Were any other children adopted?
No.
And are you expecting any children at this time?
I'm not.
And we're presenting the court with our conservatorship agreement and possession agreement. Is that correct?
Correct.
And is that your agreement as you understand it?
That's right.
And have you and Chris reached this agreement?
We have.
And are you familiar with Chris's signature?
Yes,
And has he signed this agreement?
he has.
And are you asking the court to grant this agreement?
I am.
No further questions, Your Honor.
Thank you, Ms. Sparks. All right, Ms. Wood, the court has heard your testimony and reviewed your paperwork. I'm granting the divorce. I'm approving all the agreements that you've reached with your husband, and I've signed your divorce decree. Good luck to you, ma'am.
All right.
Thank you, Ms.
Thank you, Your
Sparks.
Honor. Thank you.
Thanks for
Thank
clearing
you.
that up for me.
No, thank you. Thank you.
Okay, on the Cox matter, in the interest of Violet Cox.
We're here.
Here,
So we have how are y'all doing this morning?
all right,
Well,
thank you.
So y'all's paperwork is 99% done correctly, but there's one problem, and it's a problem that is unfortunately a significant one. It's a minor problem, but it's one that has big significance from a legal standpoint. And that is, so a petition to file a name change for a child has to either be notarized or it has to be what we call declared. And you file a declaration saying, Judge, I swear this is true and correct. And on y'all's declaration, y'all didn't fill it out completely. You signed it, but you didn't fill in the blanks like the date and the county that it was executed in. And so that makes that declaration, it doesn't comply with the law. So all I need for y'all to be able to grant this is to just either, if you have that paperwork with you, you can just add that in. There's 2 blanks on each of your signatures that you didn't fill in. If you can just fill those blanks in, then we can finish your case. And so I don't know if that's something y'all want to try to do today, where you actually come
Yes.
down here and get to the clerk's office and fill it in, or if y'all would like to, if it's easier on you, then you can just refile that paperwork at some point in the future. And then when you come back, it'll take us about 2 or 3 minutes to finish your case. But if y'all really want it done today, you're actually going to have to come to the courthouse, get with the district clerk and have them give you a copy of your petition. And then you can just write amended on the first page and
Okay.
fill those 2 sections out. Or you can actually come by my courtroom and I'll mask up and we can all mask up and I can take care of it here in the courtroom. If you'd like to get it done today, I'll get it done for you today, but it would require you to do that. It's okay if you don't want to do that and you want to just fix your paperwork later and come in a week
no.
or 2, that's
Oh,
fine
no,
as
no.
well.
We want to do
Whatever.
it.
let's,
You wanna-
we,
Yeah.
yes,
So if you'll just need to come to the Fort Bend County Courthouse, and do y'all know where that is?
Yes, sir.
Okay. And you'll go up to the 3rd floor to the district clerk's office, and you'll want your case number. Do you have that with you?
I believe we have it on file.
can we get it again?
Yes, let me give it to you.
Written on the paperwork.
It's,
You might as well get it again.
it's on the paperwork, but it's 20 DCV 278402. But if you don't have that number, then I think the clerk charges like $1 or $5 to look it up. So you definitely want to write that number down before you go in there, because it'll save you some money. And just tell them you need to get your petition, and they can print that out for you, and then just write amended, fill in those 2 blanks. You can sign it again right underneath there. And then just come down to I'm on the 3rd floor as well. So you
Okay.
can just come straight to my courtroom and I'll take care of you. If my courtroom door is locked, well, I'll have my bailiff looking for you. So I know it's probably going to take y'all some time, but I'm going to be here in court all day today. So I'll have my bailiff looking for you. Okay?
All
Sounds
right.
good. Thank you.
All right. Okay, and then the last agreement I have is on the Shannon matter. See, I have Mr. Shannon and Ms. Norris.
Yes.
And y'all actually have 2 cases, right? We have a name change as well as a divorce.
Yes, Your Honor.
Let me pull that up.
Yes, sir.
The child's not quite 1 year old, is that correct?
Yes.
Yes, sir.
And y'all are just wanting to hyphenate the name?
Yes.
Okay.
Yes.
And looks like all your paperwork's in order for that, so I'm going to take care of the name change first. If Mr. Shannon and Ms. please raise your right hand for me. Mr. Shannon, if you can raise your right hand for me.
Oh, yeah.
Do each of you solemnly swear or affirm the testimony you're going to give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Both of you had filed a petition with this court to change the name of your child, to change it from the last name Shannon to the last name Norris - Shannon. And I'll ask you, Ms.
Yes.
Norris, first. You can put your hand down. I'm sorry. Ms. Norris, do you feel like that the name change is in your child's best interest?
Yes, I do.
And Mr. Shannon, do you feel like this name change is in your child's best interest?
Yes, sir.
All right, the name change is granted, and I have signed your order. Now we're going to move on to the divorce. Oh, there are a couple of blanks in your order. Let me fill these in real quick. Okay, let's go ahead and do the divorce. Ms. Norris, you actually are the petitioner, so do you know what to say, or do you need me to ask you questions on your testimony?
I'm gonna need you to ask questions. Yeah,
Okay.
I don't, yeah.
Ms. Norris, are you presently married to Jeremy Shannon?
Yes.
And immediately before you filed this petition for divorce, did you live in Texas for 6 months and Fort Bend County for the 90 days?
Yes.
Has your marriage to Mr. Shannon become so bad the two of you can't live together as husband and wife? And if the court were to not, if I were to not grant you a divorce today, is there a good chance the two of you could go back to living together as husband and wife?
No.
There was one child born during this marriage, and that's Kinsley.
Yes.
Any other children born or adopted during the marriage? Are you presently expecting a child?
No.
And have you reached an agreement with Mr. Shannon concerning custody, visitation, and support insurance for this minor child?
Yes.
And do you feel all those agreements that you've reached with Mr. Shannon are in the child's best interest?
Yes.
Have you also reached an agreement with Mr. Shannon dividing up any assets and any debts that the two of you have?
Yes.
And do you feel that agreement is fair to both you and Mr. Shannon?
Yes.
And finally, you're asking that your name be changed from Kaylee Brianne Shannon to Kaylee Brianne Norris. Is that correct? And are you asking for that name change in an effort to avoid any kind of criminal charges or any of your creditors? And have you previously gone by the name Norris? Is that your maiden name?
Yes.
Thank you. Mr. Shannon, do you have any questions of this witness?
No.
Mr. Shannon, I'm going to ask you a couple of questions as well. If I were to ask you all the same questions that Ms. Norris just testified about, would your answers be the same or similar?
Yes, sir, they would.
And do you feel all these agreements that you reach with Ms. Norris are in Kaylee's best interest? I'm sorry, Kinsley.
I'm sorry, what was that? It broke it out.
Yeah, I was asking if you feel all these agreements that you've reached with Ms. Norris are in Kinsley's best interest.
Yes, sir.
And you're asking me to grant a divorce this morning?
Yes, sir.
All right, the court has heard your testimony. I'm approving all the agreements that the two of you have reached. I'm granting your divorce. Ms. Norris, I'm also granting your request for your name to be restored back to Norris, and I'm signing y'all's order. Y'all can get a copy of this order at the district clerk's office. If you'd like to get a copy of the order, you can contact the Fort Bend district clerk, and they can get you a certified copy of the order there. Okay, thank you, and best of luck to both of you.
Thank you.
Thank you, sir.
You're welcome. Give me 1 second to catch up on these docket entries, and then we'll take up the next matter.
Mr. Zader, go ahead and turn on your video, please.
So I need the name change on that. DCV 281395. It's not on the docket. It's a related case to that divorce. That's 281395. Thank you. Okay, if you'll make a note of that, just that case number, I'm gonna come back to that in a second. I'll get one from the library. Okay, I'm gonna get on the record here for this. The court's on the record in cause number 20 DCV 275209 in the matter of the marriage of Marietta Zader and Richard Zader. Ma'am, if you would please, Ms. Zader, if you would please state your name for the record.
Yes, my name is Marietta Stephanie Zader.
And Ms. St. Ives, if you would state your name and the party that you represent for the record.
Good morning, Diane St. Ives, and I represent Richard Zader.
And Ms. Zader, we're set for final trial today, is that correct?
Are you asking me? Are you asking me, Your Honor?
Yes.
You know what,
I said, are you-
I don't have any representation yet, and I don't have any funds. I've been a housewife for over 10.5 years. I've not been allowed to work, keep any savings, credit cards, and I feel like I need proper representation on this. This is not right. I need either help with funds or I need some time frame to get some help. Basically, what I'm asking is a reset. I need some help either getting in my household. All of my belongings have been there for over 6 months. It took 3 months almost to get even my expired identifications from Mr. Zader. As I did that, I was able to get a job. I haven't worked in 12 years since I've been with Mr. Zader. I've been his dependent. I also want visitation with my dogs.
Ma'am, hold on 1 second. I don't want to get into all the evidence today yet. It may be that we do that in a minute. I'm going to give you plenty of time to argue everything that you'd like to argue. But right now, I'm trying to determine, is this case going to trial today? Is it going to mediation? And so I just need the questions that I ask answered. So I'm going to go to Ms. St. Ives, and I'll come back to you in just a minute. Ms. St. Ives, what do we have set for this morning?
We are here for final trial, Judge. We have, this is a case that involves family violence, aggravated assault with a deadly weapon. It's a felony that Ms. Zader has been charged with. And she's not even allowed near the residence. So this issue on the clothes and all of that property, that her personal effects would need to be addressed through the district attorney's office and her criminal attorney. Ms. Zader, this is our third setting, and the second setting was during the freeze. So that was just a reset. But this case has been pending since last July. These are Ms. Zader's pleadings. We are asking that the court waive the requirement for mediation due to family violence, and we're requesting that we proceed to trial today to finalize this so Mr. Zader can move on with his life.
It appears that the attorney for Ms. Zader withdrew in January, on January 4th. That was Ms. Zand or Ms. Gordon. All right. Here's what I'm going to do. The court is going to grant the motion to waive me. You said this is a small estate, Ms. St. Ives, is that correct?
Yes, there's some real property in retirement, most of which is separate property. And that's about it. And you were asking that she be awarded some damage, a lot of damages that she caused to the house, things like that. But it's just mostly just going to be testimony and a property division. There are no children.
Okay. Here's what I'm going to do. Since the court requires mediation in every case, and that's a local rule that's been around forever. I'm telling this to Ms. Zader. I know Ms. St. Ives, you know all this. But the court has always required mediation prior to a final trial. There is a provision in our law that says if there's family violence, the court can waive mediation. And if someone files an objection to mediation, then we have a hearing on that and we determine, are we going to mediation or not? And so what I'm getting this morning is an objection to mediating. And I'm going to grant that request. I'm not going to force y'all to go mediate for a couple of reasons. One, there's family violence, which sounds like the allegations are very serious. And so I don't feel that it would be in the party's best interest to attend the mediation. I'm not going to make Mr. Zader do that. The only issue I have is since I'm doing that today and I've got a party that is not represented by counsel whose lawyer just withdrew about 45 days ago, I think the appropriate thing for me to do is I'm going to reschedule the trial one time. But Ms. Zader, I want you to listen very carefully to me because I'm going to make a detailed docket entry of what I'm telling you. I'm rescheduling this case for about 30 days. I'm going to get a date in a second from you and from Ms. St. Ives. The reason that I'm doing that is because you're not represented by counsel today, and I find your counsel just withdrew about 45 days ago. But that being said, and I know there's been a freeze, there's been some issues going on that were beyond your control. But here's the thing. The next trial setting that I give you, we are going to trial that morning. And so if you show back up and you say, Judge, I don't have an attorney, I need more time, that's going to fall on deaf ears. You need to get if you want to have an attorney representing you in this case, you need to have them at the next setting because the next setting is we're going to trial. And I'm going to make that clear. The reason I'm not doing that today is because I don't feel like you necessarily had noticed that we weren't going to send you to mediation under the local rules. And so I'm going to give you, I'm just erring on the side of caution to give you some additional time. Ms. St. Ives, I know y'all are ready to go. I know your client is ready to get this over with, but I just feel like this is the fair thing for me to do is to give one additional setting. Mr. Zader, we're going to go to trial on your case the next time. I understand your lawyer has argued eloquently today that she wants to go forward today and that you want to go forward today. But I'm not going to do that yet. I'm going to have one more setting, but I am taking notes of what I just said, and we are going to finish this case the next time y'all are in. Ms. Zader, if you have anything that you need to get in front of the court, you need to get an attorney and or you need to prepare without having an attorney because we're going on the next setting. Okay, let's look at when to do that. Thinking about 30 days out should be fine, which would put us in the week of April the 12th, any day that week, or Ms. St. Ives, if you want the week before, the week after, that's fine with me as well.
Your Honor, I'll be coming back from a vacation that week and go into a bunch of other things. So the week of the 19th would be a good day, Judge.
Okay, Ms. Zader, that gives you a little more time. Would you like April the 19th at 9 a.m. for your trial date?
That would be proper. Thank you, Your Honor. And Your Honor, I have a couple.
Okay, and well, hold on. I'm not gonna. Just a second. I also would recommend, Ms. Zader, that if you have a list of personal property that's in the house, if it's clothing or it's little, trinkets or things that you really want, or maybe it's more significant stuff, like there's a piece of furniture or something that you want there. What I would recommend you do before April the 19th is send that list, email that to Miss St. Ives, and just say, these are the things that I'd like out of the house. It may be that there are some dishes, or there are some towels, or there's some things that Mr. Zader says, you know what, you can have those. And that way, when we come back here, I'm not trying a case over pots and pans. And so I would prefer, Ms. Zader, for you to do that. So just make a list of anything you want out of the house and send that to Miss St. Ives. And that way we can at least narrow the issues that are in dispute prior to coming back here. Because I know a lot of times we focus on the big stuff like retirement accounts and houses and stuff like that. And then we end up not having enough time to deal with a lot of the really small stuff, and it can make the case take a lot longer. So send Miss St. Ives anything you want out of the house prior to the next setting, okay?
And Your Honor, if as long as my client's agreeable to the list, I'm happy to have him deliver it to my office and she can pick it up there, so she's not going to be violating any of her bond conditions.
Right, and I was going to say that too. I'm assuming that it's a bond condition since it's been so long since the charges were filed. But
Correct.
ma'am, there's nothing I'm doing today that is allowing you to go to the house. That's a different judge and a different court, but they have set that as a bond condition for you, which means you want to stay out and maintain your freedom until this criminal case gets to trial. You have to follow those provisions very carefully. So if they get your list and it has, let's say, 20 things on it, and Mr. Zader looks at it and says, I'm okay with 10 of these things, he will make arrangements to get that to Miss St. Ives' office or somewhere where she can direct you to go pick up the items. That doesn't mean you're not going to get the other 10 items. It doesn't. What that means is I'm only going to have to hear those 10 items where y'all disagree. Does that make sense to you, Ms. Zader?
Yes, Your Honor.
All right. All right. Trial is rescheduled for April the 19th at 9 a.m. And I'm making a docket entry that the motion to mediate, or motion to waive mediation is granted, and that takes care of that issue. Anything further we need to address on the record from either side?
Nothing here, Your Honor.
Ms. Zader, anything else you want to address this morning?
Your Honor, my only concern are 2 dogs that were acquired during the marriage, and I've been the primary caregiver for 7 years. And how do I address that as to visitation or keeping them as property? Because I do want them. I'm not concerned about
Did you say?
the dogs, 2 dogs.
I didn't quite hear you. Did you say, are you talking about animals, 2 dogs?
Dogs, 2 small dogs that were acquired during the marriage. How do we proceed with
Yeah,
that?
I'm not going to get into that today. If you want 2 dogs, and you would put that on your list, and then Ms. St. Ives can talk to Mr. Zader about that and see if y'all agree on that or not. If you don't agree on it, then I'll deal with the dogs on the 19th of April. Okay? All right, thank you all. Y'all are excused.